right. So asset protection, protecting the family home. All right. So our primary concern, all right, is twofold. As I was just sharing a little bit, it's not only the home itself, all right, but as an elder care law firm, it's also the family inside. Okay. We focus tremendously, and all good firms that do this type of work focus not only on, as I call it, the documents and the dollars. They're not just focusing on the assets, but the family, all right, the personal care issues, the dynamics, the communication. This home is where this house is where home is, right? So I'm sure most of you can agree with that. So, what exactly are the risks to the family home? There are several, but I'm going to be talking about two big ones today: long term care and probate. All right, two separate issues that can hit. And if you're not planned for to deal with those issues, then they can be devastating. They can cause stress, they can cause financial hardship, they can cause tremendous tension and a breakdown of family dynamics. But let's get into a little bit as to why these are risks. Again, not with too much depth because we've covered it in the past, but I want you to understand why it's a risk. Okay. So, long term care first. Why is long term care a risk? Well, two reasons. Long term care can be very, very expensive. What do I mean by that? And for that matter, what exactly is long term care? So, we'll take a step back. Long term care is receiving care, is being in need of care that revolves around our functional abilities. Okay, so it's not long-term care, not is not our medical needs. So it's not doctors and hospitals and rehabilitation facilities. Long-term care is care we receive inside of our home, perhaps inside of an assisted living, or even inside of a nursing home. All right, and that type of care is very expensive. Why? And again, I covered this in one of our prior webinars, how to pay for this long-term care, because your health insurance and Medicare does not pay for long-term care. When it comes to long-term care needs, getting help with the activities of daily living, walking, bathing, toileting, dressing, it's really up to us to pay for that care ourselves. Or for those folks that have long-term care insurance, they can use that if it's sufficient enough. Or for the vast majority of us, they end up on the Medicaid program. All right. So these are the two reasons why we have to deal with long-term care issues as a risk. Now, long-term care itself, you're looking at home care can be anywhere from $25 to $35 an hour, can be $300 a day, can be over $2,000 a week for home care, can be over $10,000 a month for home care. Nursing home care can be anywhere from $14,000, $15,000 a month up to $20,000 a month. So those costs are extreme, all right? And that's why we're going to need the Medicaid program to actually pay for that type of care, all right? So we'll get into it a little bit more. Now, 5 quick points about Medicaid if you haven't caught the prior webinars or you're not familiar with the program itself. Medicaid itself, in order to become eligible for the program, in order for them to pay for care in the home or to pay for care in a facility, they're going to focus on assets, they're going to focus on your income, and they're going to focus on your care level. All right, what are your care needs? Okay. In addition, as I've said, there are 2 programs for Medicaid. You have home care, which is also called community Medicaid, and then you have nursing home Medicaid, also called chronic care. All right. So those are the 2 programs that are out there. Now, the last point is actually the most complicated point, and that has to deal with eligibility. All right. They're looking at assets, they're looking at income, they're looking at care, and there's different thresholds and strategies that we can utilize to make somebody eligible. However, one thing I want to call your attention to is that the community Medicaid program, as it has stood for so many years as a program with pretty straightforward eligibility and access, is changing entirely come October 1st. All right. So come October 1st, community Medicaid is going to have a look back period, and community Medicaid is going to have a penalties associated with any type of asset protection steps taken within the look back period. Okay. That look back period has always been reserved for nursing home Medicaid. However, as of October, it now applies to community Medicaid, which means the time to protect and the time to plan is as soon as possible. All right. And I'll get into a little bit more of that at the end. All right. Now, the reason Medicaid is a concern, another reason Medicaid is a concern as far as the assets, is Medicaid actually tells in their rules that an applicant can keep their home in their name. The problem with that, though, is that once that house is vacated or the Medicaid recipient passes away and the house is now empty, Medicaid can put a lien on the property or they can pursue the home through what's called estate recovery. Again, I'll bring that up again in a little bit. So, Medicaid is a concern for the house in particular because of those two reasons. Okay. Now, the other risk to the home is probate. And probate, and unfortunately, I'm sure most of you have been through that process. It's where somebody passes away with assets in their name alone, okay? Meaning no joint owner, no beneficiary on the account, and no trust as the owner. It's in the decedent's name solely. And if that's the case, you're going to be involved in a long, drawn out court proceeding called probate, and you can skip it if you want. You just have to take steps to do so. All right. Let me tell you some reasons why you want to avoid probate. Now, there are going to be delays. All right. You're going to have a court filing proceeding, court filed petition that will take time for the attorneys to put together. You're going to have time for the courts to review it, and there's going to be delays. Okay. Generally, a probate proceeding can be anywhere from 5 or 6 months up until years. All right, if problems like litigation arise. Okay, so that's one reason you want to avoid probate. Think about it in regard to your home. If mom and dad pass away and that home has to go through probate and you want to sell it, you can't sell it until you go through the probate proceeding. You have to be appointed an executor in order to have the legal authority to technically sign contracts, sign a listing agreement, even, and of course, go to the closing. So the probate process can greatly delay dealing with mom and dad's house. You'll have to maintain insurances. You'll have to keep the heat and water on, the utilities. You want to protect the house from vandalism, from squatters. All of those things can happen with an empty house during probate, okay, because of these delays. In addition, you're going to have costs and fees associated with probate. There's a court filing fee upwards of $1,250. You're going to have legal fees. All right. You can have accounting fees, which will happen anyway, but there may be more because of the probate proceeding. Okay. Moving on, this is a huge issue, the issue of privacy. The courts are public, and there are literally companies that are inside the court clerk's office, even within the surrogate's court where the probate proceedings occur, literally going through the probate petitions. They are seeing assets. They are seeing family names. They're seeing family addresses. They're seeing if somebody is a minor. They're seeing if somebody is disabled. All of that is in the court petition for probate. And in this day and age of identity theft, of fraud, of shady characters, you don't want that out there. You want to keep things private. And the probate court does not do that. Another reason you want to avoid probate, and again, the delays that go along with inheriting the home or selling the home, is the concept of distributees. A distributee is a family member that is entitled to inherit from you. Typically, a distributee is going to be a spouse and the children. Okay, those are the distributees. The reason it can be an issue is if you are disinheriting a child, or if you have lost contact with a child and you don't know where they live. What you're doing is the court is going to force your nominated executor to locate, at least to spend time and energy through due diligence to find that missing heir, or if they can't, or if the situation is where you're disinheriting or different percentages for your children, you are giving that child the opportunity to challenge the estate, because the probate proceeding will require that every distributee, every child, sign off on the will that's being admitted to probate. And do you think if a child is being disinherited that they're going to want to sign off on that? They're not. The court actually gives them the opportunity to hire a lawyer and show up and delay and drag things on and cause problems. Again, causing more delays. So another reason to avoid probate, if you have real estate outside of New York, so you can have your family home in New York, that's your primary residence, you can have a vacation home in any other state. And that applies to our topic today because you're talking about your real estate. Now, if you pass away in New York and you have real estate outside of New York that's in your name alone that did not avoid probate, then you're going to have two probate proceedings, or at least one with an add-on in another state. Okay. So real estate outside of New York will require probate unless you take steps to avoid it. Okay. The next reason to avoid probate is a pretty current reason. It's this concept of a court backlog and closure. They've been closed for months and they are only starting to open up over the last couple of weeks. So literally, if a parent passed away again and you had to sell your house and you wanted to get on the market for the springtime, you weren't able to get your probate petition reviewed. You weren't appointed executor. You're not able to sign contracts and go to a closing because the courts were closed. Okay. So avoid that proceeding altogether. All right. Now, as I mentioned earlier, Medicaid estate recovery and Medicaid right of election. Those are the two Medicaid related reasons that you want to stay out of probate. Estate recovery first. If somebody is on Medicaid, if they're receiving Medicaid, this long-term care Medicaid that we do here to help our clients, and that person passes away, if there are any assets left in that client's name alone, meaning they're not avoiding probate, so they're not joint, there's no beneficiary, okay, they're not in a trust. If there's an account out there in the Medicaid recipient's name alone, that has to go through probate. And the law requires New York State to go after it and to collect it. Okay. So estate recovery is something you want to avoid. And as I mentioned in the beginning, you can have your house in your name because, perhaps a Medicaid preparer person that's not a lawyer just reads that part of the law that says, oh, they can keep the house, keep the house. That's not going to be the best way to go. You need that house out of the Medicaid applicant's name in the context of the whole plan and penalties and look back period, of course, because when they pass away or vacate, Medicaid, pursuant to estate recovery, is going to go after it. Now, the other issue is Medicaid, the right of election. Now, this happens when you have a married husband and wife, or spouses, we should say, and the community spouse, which is the one living in the home, that one passes away first. So if the well spouse, also what they're called, living in the home, passes away first, then Medicaid has the ability to stand in the shoes of the Medicaid recipient and pursue an estate claim against, let's say, their wife living in the house. All right. Now, why is that an issue? Well, because when you have, in the example, if we have dad on Medicaid in a facility and mom is well living at home, mom is going to have a new last will and testament, or mom is going to have her own revocable trust, in essence, disinheriting her husband who's in a facility on Medicaid. And if mom passes away first, those assets are going to go to the children. That'll be the plan. Okay. Again, steps that have to be taken. And if that occurs, Medicaid will be put on notice if they're going through probate for sure, because they're going to be a party to the proceeding. They'll have to be on notice. They'll have the right, again, to stand in the dad's shoes and collect what's called the right of election. So in New York, you're not allowed to disinherit your spouse. You must always, or I shouldn't say it that way, they are entitled to receive at least 1/3 of the other spouse's assets. Okay. You don't have to leave the assets to the husband, as we typically don't, but that husband, if they want to pursue their right of election, as Medicaid will do, they can go after the assets, including the home. Okay. So those are two very valid and real Medicaid risks that we want to avoid when it comes to the home. Okay. So how do we of course, avoid those risks as far as long-term care Medicaid and probate. As most of you have guessed, and I've received emails, I always receive emails before the webinars with questions. And yes, this is going to be about trusts. Trusts are the most flexible and best way to avoid probate and to protect against long-term care. No ifs, ands, or buts. All right. But let me talk a little bit about it. A trust is nothing more than a written agreement that manages your property. That's it. It's not magic. It's not something to be intimidated by. It's typically it could be a 20-page written document. It could be a 40-page written document, and it just outlines and details how your property should be managed if you are alive and healthy, if you are alive and not healthy, ill, or lack of capacity. And then the final segment of a trust will detail what to do with my property once I pass away. Okay. That is all the trust is going to detail in that written agreement. All right. It's not more complex than that. Now, every trust has to have 4 parts. All right. Every trust has to have a grantor. That's the creator or the person granting the trust. Every trust has to have a trustee. That's the manager of the property, the manager of the trust. Every trust has to have a beneficiary. Depending on the type of trust, it could be very simple, or it could be a little more complicated. You can have lifetime beneficiaries. You can have what's called a death beneficiary. You can have an income beneficiary, and you can have what's called a principal beneficiary. Whatever is inside the trust, that's called the principal. All right. Now, the 4th part of a trust is the property itself. You actually have to have something go into the trust to be held by the trustee. So again, grantor, trustee, beneficiary, and the actual property that would go into the trust itself. Now, there are different types of trusts, but for our purposes, we're going to narrow it down to revocable and what's called irrevocable. Okay. So a revocable trust is one where the sole purpose of the client, of the grantor, is to avoid probate. Okay. Then you use a revocable trust. If the purpose and goal of the client is to protect, if the goal and purpose of the client is asset protection for long-term care and Medicaid, then you're going to be looking at the irrevocable trust. All right. Now, let me share a nice way, a visual way of summarizing this. Again, we have 2 types of trusts, revocable and irrevocable. We have 2 reasons why people do trusts: to avoid probate and to protect their assets. Okay. Now, the revocable trust avoids probate. We've already said that. The irrevocable trust, because it's a trust, also avoids probate. Now, the irrevocable trust, the way it's drafted, the terms within the agreement itself will provide for asset protection. That's the purpose of the irrevocable trust. Now, the revocable trust does not have the same protection language as the irrevocable. So it does not protect against long-term care and does not protect against Medicaid. All right. So when it comes to certain planning and protection strategies, the irrevocable trust wins hands down. It's the better vehicle, the better tool. Okay. So let's talk a little bit about the irrevocable asset protection trust. Okay. Now, the first one I'm going to talk about, without too much depth because of time constraints, and I cover it again in our other Medicaid webinars, and I'll be covering it again next Wednesday, all right, is this concept of a Medicaid look-back period. Every asset protection step that a client takes, such as putting their home into an irrevocable trust, will be subject to a Medicaid look-back period. Okay. Now, the Medicaid look-back period is, if I can say simply, a review of every financial account, asset, transaction within a certain time period. For a nursing home Medicaid application, it is a 60-month look-back period. So for 5 years, you have to show both husband and wife every single page of every single financial statement for every single month over 60 months. That's for a nursing home application. Under current New York law, there is no look back period for home care. All right. So literally, a person can protect all of their assets in July and apply for community Medicaid in August. In fact, we are doing that for dozens and dozens of families right now. They're realizing that there is a care need, and they are realizing, after talking to us or reading and doing their own research, that community Medicaid is changing entirely in 3 months. So they are rushing to get us all the paperwork so we can protect what we can protect and hopefully get an application in before October 1st. Okay. Come October 1st will be that 30-month look back that you see there on your screen. Now, the other big rule about irrevocable asset protection trusts is what's called the principal. All right. So, as I mentioned 2 minutes ago, every trust will have assets in it. That's called the principal. In order for it to be an asset protection trust, we have to implement what I call the no principal rule. And for an asset protection trust to be effective, it must state in black and white that no assets in that trust, no principal, can be distributed back to the grantors or used for their benefit directly. All right. So nothing in the trust can go back to mom and dad directly. Now, if you have income generated, that can go because that's not principal. That's the first point. The next point is the trust will allow for provisions where distributions can be made to children instead of mom and dad. Okay, it's a technical point, and I get into it during our consults a lot more, as well as in prior webinars. But money can come out of the trust. It just has to go to a trusted child first. Okay. Now, income, as I just mentioned, yes, an irrevocable asset protection trust will typically say income will get distributed out to mom and dad. Okay. The trust should very clearly state that mom and dad have the right to live in that house for the rest of their lives. That gives them security. Okay. And quite honestly, if I was to start polling my clients as far as, do you want security for you and your spouse for the rest of your life? Or is your main goal to just make sure it's there for your kids? They're going to talk about security more. All right. And that just makes sense. And as their attorney, I'm going to make sure that happens. So giving mom and dad or husband and wife, the clients, the right to live in the house, crucial. Okay. Now, what that does, in addition to security for them, and that emotional control and security, is it keeps the real estate taxes low. Meaning, if mom and dad have a veterans exemption or a star exemption, senior citizen exemption, they keep those exemptions because of that right to live in there. Okay. In addition, the irrevocable asset protection does not lock you into that home for the rest of your life. You are able to sell the home. The trustee does it with you, but that trustee can sell the home and even buy a new home to be owned by the trust, all as of 2020. No new look back, no new 5 years. It's all within the trust, and it happens all the time. So there's a lot of flexibility, all right, as far as this irrevocable trust. Now, more flexibility, more control. The grantors, again, I keep saying mom and dad because that's typically what we're talking about here. They control the trustee and they control the beneficiaries. Now, what do I mean by that? If we have mom and dad and two children, all right, Steve and Susan, mom and dad may pick Susan as the trustee. If Susan is not acting in accordance with her responsibilities, then mom and dad can fire Susan. Okay. So she does not have to remain as trustee. Mom and dad are not stuck with her. And if they fire her, then Stephen can step up perhaps as the successor trustee. Or mom and dad can even appoint an outsider altogether to come in and be trustee. So you're not locked in to who your trustee is. You can remove them and replace them. All right. As far as beneficiaries, and this is huge, just because you have an irrevocable trust, you are not locked in to keeping the same beneficiaries that you wanted at 70, 75, 80 years of age. You can always change your beneficiaries as long as the trust is drafted properly. It needs what's called a power of appointment. And there's different ways to craft that type of language. But The idea here and the flexibility is you can name your two children, just like I said, Stephen and Susan, in your trust as 50-50 beneficiaries. But again, if Susan heads off to Vegas and you never hear from her again, but you are very close to her children, you can cut Susan out as a beneficiary and skip her and have it go to her grandchildren. So you always have that ability to modify your beneficiaries. Okay. Now, more flexibility. The irrevocable asset protection trust for Medicaid purposes, we like to include an option called a trust protector. All right. So we've talked about the flexibility thus far: trustee, beneficiaries, ability to sell, ability to stay. But if there's any other substantive issues that come down the pike, if, for example, if New York State should change a law in relation to Medicaid and an irrevocable trust, you're not allowed to change it. That's where you're going to be limited. However, if you appoint a trust protector, which is an unrelated person, not in the family, that person, again, typically close and knows what your objectives are, that trust protector is able to modify the trust itself. Okay. So more flexibility is built into it, especially in regard to the home. Now, taxes. Very briefly, this type of an irrevocable trust, as we draft it, is tax neutral. It is not going to increase or decrease income taxes, real estate taxes, or capital gains taxes. All right? Very important point. And finally, I sometimes don't like saying this part, but it's true. An irrevocable trust, as long as the grantors, the trustee, and the beneficiaries agree, the trust can be revoked. Okay. It is entirely revocable, which again gives great amounts of flexibility and control down the road. Now, you have to have a trustee that's agreeing. And as we already know, we can fire and replace if we have to. Your beneficiaries have to agree. Again, you know, you can fire and replace or remove your beneficiaries. So strategically, we come up with different plans and ways of handling what the family needs. And again, if it's necessary, and we hope it's never necessary, but an irrevocable trust can be revoked. Okay. Not something to take very lightly. Now, on occasion, I've got clients say to me, well, you know what? I'm just going to give it to my kids. I'm just going to sign the deed over. I'm going to give them the house, or I'm just going to give them the $100,000. Let me caution you, that's not the best way to go. All right. Let me explain why. So, why can't I just give it to my kids? Well, I call it the D's. All right. The D's. So, I'll give you my reasons. If a child dies, all right, it's unfortunate, but it happens. If that child is holding your $200,000, now what? Right? Does it go to the spouse? Does it go to the children? What if there's a disabled child? What if there's a minor child? It gets very, very messy very, very fast. You lose access, you lose control, you get into probate delays probably. Okay. Bad idea. Another reason, what if a child that is that owns your house develops a disease, becomes ill? I've seen this personally with clients. Give the house to the son, married to the daughter. They've got 3 kids. Everybody's living happily in the house. Son contracts an illness and dies. The wife remarries. They don't want mom in the house anymore. They can kick her out. I've seen it happen. Okay. Wasn't actually a client where it happened, because we would have done what we could have to prevent it or minimize the problems. But a client came after that had happened. So it can happen. Divorce. If that son of yours is holding $200,000 and they're not doing it properly and he gets divorced, guess what? That attorney for the spouse is going after it. Okay. Sometimes there are drug issues or incarceration. Children go through things, as we all know, and maybe you don't know about it, and the money can be spent that way. Okay, another risk. If a child has financial problems, again, not every child tells their parent everything. Bankruptcy, creditors, all right, outstanding debt, that money can be lost, or property can have liens put against it. Dishonesty. There does happen where a child misuses the money. If it's in their account, they can do what they like with it. A loss of security. Let me talk about that a little bit. If you give a house to a child, as I just shared a little bit ago, or give the cash to a child, they are in control. You are losing that control and losing that security. There was a story a number of years ago in Newsday about a house given to it. A mom gave the house to a child. That child kept her locked in. I don't recall if it was the attic or the basement, but both are horrible, because he felt he was the owner. He felt he was in control. There's a loss of security when you do not have control built into the strategy. Okay. To keep with the D motif, I use the word duty, but that means taxes. Okay. So if you give your house to your child, your real estate taxes are going to increase. You're going to lose your exemptions. That child is going to get hit with capital gains taxes. If they sell the property, they will have a capital gains tax on the profit. If they sell the property even after you pass away, they're going to get hit. The reason I talk about passing away is because if you use a strategy like an irrevocable trust and they inherit it, all those capital gains taxes disappear. Okay. So increased taxes is another reason to not do an outright transfer of a house or cash to children unless it's a part of a plan. Okay. We often will have children hold some money from mom or dad as they're going through different stages of life. But again, it's a part of a plan, and it's balanced out. Now, I'm going to use this time to talk about a life estate for a brief moment. A life estate is a very simplified way to protect your home. It cannot protect investments or money. It can only protect real estate. It's simply a deed. It's the 1-2 page deed that says, I, dad, give my children my house, but I reserve the right to live there. So it does give security. That's a plus. It does keep the real estate taxes down. That's a plus. It does avoid probate. That's a plus. It minimizes the capital gains taxes. That's a plus. But for me, the negatives outweigh all those positives. All right. For a client that uses a life estate, there are no contingencies built into a life estate situation typically. All right. So I'll give you an example. If mom and dad give the house to Steve and Susan, like we've said in our example, and mom and dad have the right to live there, all good stuff. But let's say Stephen passes away. Now what? Where does his half interest go? To the spouse? To the kids? What if the kids are minors? What if the kids are disabled? Again, there's no contingencies built into a simplified deed. Okay. If we use an irrevocable trust instead, like I said earlier, we've got 30 to 40 pages of contingencies that we can build in. If this person passes away, then this happens. If this person is this age, then this happens. If this person is disabled, God forbid, then this happens. You lose that ability. Okay. In addition, you can't change beneficiaries. Okay. In an irrevocable trust, you go to the lawyer, you sign a piece of paper, the kids don't even have to know about it. You cannot take that house back with a life estate. You can't remove those kids as beneficiaries with a life estate. So again, those two main reasons, we don't do the life estates. All right. The irrevocable trust, hands down, is a more comprehensive, more flexible tool. Okay. So when should I start my asset protection? Well, what do you think I'm going to say? I'm going to say now. All right. Especially now that we have that change coming for October 1st for community Medicaid. I used to say 70 years of age, start getting asset protection done. I'm now saying 65, 67 years of age and earlier if you already have health issues. Okay. So the sooner the better. If you have care needs, you got to start dealing with Medicaid. You got to start dealing with the protection now. And we're here to help. Very honestly, though, we're running out of time. Okay. We've got less than 3 months. So, the way that we undertake our irrevocable asset protection is what we call an elder care protection plan. Okay, the elder care protection plan is where we combine estate planning, incapacity planning, asset protection planning, and we help the family prepare for future care. All right, so the elder care protection plan is not just a trust. It's not, oh, let me get a trust and then go on my way and I'm done. It's a transaction and it's over with. An elder care protection plan is a relationship where we are helping the family prepare for care. And while we're doing it, we're taking care of assets, we're protecting assets, we're dealing with incapacity issues. All right. And that's year to year. We have a maintenance plan built into that so you're not alone. Okay. Now, one of the last points I want to make is if you need care now, all right, you still have to protect that home. You still want to avoid probate. What we utilize is a program, a system called life care planning. If you're younger and healthier, health is on your side, the elder care protection plan is the way to go. If you have a care need now, then you need to start looking at Medicaid and all of everything that goes with it now because of, again, these changes coming in October. A life care plan is very unique, and I'm very proud of how we offer these services for our families. It's where the attorneys that work in my office work together with advocates that we have on staff. We have a full-time geriatric social worker. We have a full-time board-certified patient advocate. We just hired another full-time geriatric social worker that'll be starting shortly. She's been working with residents of nursing facilities for the past 16 years as the director of social work. She knows care management. They all know care coordination, how to assess, how to advocate. So while the attorneys are focusing on asset protection for the home and other assets, while the attorneys are focusing on getting Medicaid to pay the bills, the advocates are representing and advocating for mom and dad and supporting the caregivers through the whole process. So we bring together the legal, the financial, and the care into one service. And again, it's what's called life care planning. Okay. If you have questions about that, please, all right, reach out to me. My email is right there, brian@tullyelderlaw.com, TULLYELDER law.com, or the phone number for the folks on the telephone, 631-424-2800. I'll be taking some questions. If you have a question, please get it into the comment box or the question box it should be in the top middle of your screen. Check out our website, tullyelderlaw.com. Again, the video section will have our different webinars. Facebook is a great way to stay in touch and learn about new developments as well. Okay, so let me see if we have questions and we'll go from there. Okay. All right. So are properties only in the trust or also financial accounts? Good question. The good thing about a trust in an irrevocable asset protection trust is it can own real estate and it can own investments and banking. 2 points. 3 points. You never put all of your assets into the irrevocable trust. You always leave enough outside so that the client is comfortable and has enough control. We don't want moms and dads having to ask kids for money. Okay. So, number one, you balance out what goes into the trust and what stays out of the trust so you can use it freely. Okay. The other point is IRA accounts, retirement accounts never go inside an irrevocable trust. That includes qualified annuities, that includes 403B, 401k. Those are all retirement accounts. They must stay in your name and your social security number. Okay. And the third point was because it's an asset protection trust, like I said, you want to keep enough money out. The everyday banking money, that never goes into the trust either. Okay, the irrevocable trust. You always keep your operating accounts outside of the trust. All right. Another question is, should an IRA be placed into an irrevocable trust? And as I just shared, no. You have to keep that outside. Sometimes you can have a trust as the beneficiary, okay, of an IRA, but that's not always something that you want to do either. It depends on the circumstances. Okay, cost basis and looking at capital gains taxes. Sure. So the question is, well, again, it's about capital gains taxes, so I'll explain it through cost basis. When an asset is given away, so let's say my mom gives me the house, okay? Not only will my brothers be upset, but just for the example, if mom gives me the house, there is something called a cost basis. That is how much mom bought the house for. let's say $30,000. Okay, they're over in Malvern. They bought it for 30 grand. I think I was 1 year old. Okay, 1971. So they bought it at 30 grand. It's now worth, pick a number, say 400, 500, $600,000. We'll go right in the middle. Say the house is worth 500,000. What they bought it for to what it's worth today is gain. That's profit. Okay. So if they sell, they can get hit with what's called a capital gains tax on that profit. Okay. Now follow me. That basis, what they paid for it, determines what the profit is. Now, basis can be increased if they make certain improvements to the house over the years, or if a spouse passes away, there can be a partial step up in the basis because a step up occurs when you have one owner pass away. Okay, meaning that the cost basis in the property is now fair market value. All right, so the way it works is, again, what it's bought for, what the capital improvements are made, and what it's sold for. So right now, there are two capital gains tax advantages. Okay, right now, if mom sells the house or mom and dad sell the house, they each have $250,000, a $250,000 capital gains tax exclusion. So they can each shelter 250. Combined, they can shelter $500,000 worth of profit if they sell it during their lives. The irrevocable trust keeps that. Okay, you do not lose that capital gains tax benefit. The other place we see basis and capital gains and this concept of a step up is when the clients pass away. All right. So gratefully, thank God, mom and dad are still with us. But if something happened to them yesterday, okay, and it didn't happen, thank God. So if something happened to mom and dad yesterday, me and my brothers will inherit the house at fair market value, meaning we receive a step up in the basis. So what they paid for it and what they put into it no longer matters. What matters is the fair market value on the date of death. That's what we inherit. That's called a step up. So if we sell the property, again, no capital gains taxes. The good news, again, is the irrevocable trust keeps that same capital gains step up. Okay, hopefully that answers your question. Another one came up. Look back periods. Now, a look back period. So the look back period is when somebody's applying for Medicaid. There's two types of Medicaid programs, as I said. You have your chronic care nursing home Medicaid, and you have your community-based home health care Medicaid. All right. With community-based, they're sending an aid into the home. With chronic care, they're paying for the nursing home. You have to become eligible for these programs. It's not an entitlement, if you will, like Medicare, that you pay into it for years. You have to make yourself eligible. And making yourself eligible means playing by their rules. And one of their rules is you have to provide enough financial documentation to prove you're eligible. That financial documentation is called the look back period. So in a nursing home, again, 60 months, there'll be a 60-month review of your financial records to determine if you have made any asset protection steps or moved any property around, and therefore would be subject to a penalty. Okay, so the look back period is merely, although it has great impact, it's merely a review of all the financial records and financial transactions. As of now, Community Medicaid does not have any look back period. That is ending. The look back period starting for Community Medicaid in October is going to be 30 months. Okay, so it is a 2.5 year review of all of your financial accounts, which is half of the review of the look back period for nursing homes. Okay. The other question is, do we provide discounts for people who attend the webinars? I'm flattered you asked that question. We'd be very happy to help the family and discuss what the needs are and what kind of planning we can do. We have had some reduced rates because of the pandemic to really encourage people to get the planning done. So that's the kind of the discount and package and services and fees that we can talk about. All right. Another question. If you get approved for Community Medicaid without the look back and then have to go to the nursing home, what happens regarding the look back? So again, if somebody is on Community Medicaid now without a look back period and then they need to go into a nursing home? The answer is yes. There will always be a 5-year look back when somebody's going into a nursing home. All right. If you go into community Medicaid, it is not a back door to nursing home Medicaid. Okay. There'll always be that 60-month review. All right. I don't see any other questions. So I want to say thank you again. I hope you found this helpful. Next week's webinar, again, will be on Medicaid, the good, the bad, and the ugly. So please join me next week. You'll start getting the registration emails on Saturday and then Monday, and then, of course, Wednesday morning. All right. Thank you. If you have questions after this, or if you have topics, shoot me a topic. All right. I'll be happy to see if I can incorporate it into one of our webinars. Thank you again. Oh, wait, maybe another question. Oh, thank you. You're very welcome, guys. Bye-bye. Where's my exit? There we go. Take care and be safe.